Special master granted. The Trump judge finally issuing an order, and it's good news if you're Donald Trump and his defense team. Not so good news if you're the DOJ, if you are part of the FBI, if you're part of the Merrick Garland investigation that he approved personally and that Joe Biden had nothing to know about, and so on and so forth. Right? It's all coming to a head. We spent a lot of time on this channel unpacking both sides of this argument, but the judge came out and granted the special master in part. We're going to dive through this motion before we take a look at Trump's reaction in his first update since the raid on Mar-a-Lago, and we'll check in and see what he has to say over on Truth Social as well. But first, we need to go into the motion. This motion, Donald Trump versus the United States of America, the special master order coming out from Judge Aileen Cannon. You can see it's a big one, 24-page order, and this is coming up after the oral arguments that took place the week preceding, where it was a short oral arguments. It was about, I think, 105 minutes in total. 4 people from the DOJ were there. 4 people from Trump's defense team were there, and they just kind of got right into the arguments. The DOJ, remember, does not want anybody interfering with their investigation of Trump. Trump does not trust the DOJ or the FBI to rummage around through his boxes. They want somebody to mediate between all of this. We heard all of the different arguments and spent a lot of time unpacking those. This is the final ruling from the court. Judge Cannon writes, "This cause comes before the court based upon Trump's motion for judicial oversight." Remember, he filed this. He said, "I want a special master appointed." The court has reviewed Trump's additional filing, which we reviewed here, and the government's response. We also reviewed Trump's reply. So remember, these things come in like a sandwich. Trump moves, government on top, then Trump final word. The court also held a hearing on the motion on September 1, and that was a 105-minute proceeding. So the judge said, "I can't give you a ruling now. I've got to mull all this over and think it through." And here it is. She says, "Pursuant to the court's equitable jurisdiction and inherent supervisory authority, and mindful of the need to ensure at least the appearance of fairness and integrity under the extraordinary circumstances presented, Trump's motion is granted in part. The court hereby authorizes the appointment of a special master to review the seized property for personal items and documents and potentially privileged material subject to claims of attorney-client or executive privilege. Furthermore, in natural conjunction with that appointment and consistent with the value and sequence of special master procedures, the court also temporarily enjoins the government from reviewing and using the seized materials for investigative purposes pending completion of the special master's review or further court order. This order shall not impede the classification review or intelligence assessment by the ODNI, the Office of the Director of National Intelligence, as described in prior filings." Whoa, big news there. You can see it sounds like the court is ordering the government, stop, you're done. Stop rummaging through those boxes. The court temporarily enjoins, meaning you are stopped from doing this. You cannot review, you cannot use the seized materials for your investigative purposes until we are done. Get out of there, drop your pencils. It's over. It says further, we've got some relevant background after we know what the order is. The judge is going to give us a big explanation as to how she got there. She writes, "The following is a summary of the record based on the party's submissions and the oral presentation. Footnote 1. Neither party requested an evidentiary hearing on the motion, and under the circumstances, the court finds resolution of the motion sufficient and prudent on the present record." Okay, we don't need to call in additional witnesses. We don't need to have sort of people take a stand and ask them questions and present materials to them. We don't need to do that. The judge said, we heard enough in the filings and in the oral arguments. I don't need anything else. It says, throughout 2021, Trump and the National Archives were engaged in conversations concerning records from Trump's time in office. In January 2021, as a product of those conversations, Trump transferred 15 boxes from his residence over to NARA. Upon the initial review of the 15 boxes, NARA identified items contained therein as newspapers, magazines, printed news, articles, photos, miscellaneous printouts, notes, presidential correspondence, personal records, post-presidential records, and classified records. NARA subsequently informed the Department of Justice of the contents of the boxes, claiming that some items contained markings of, quote, classified national security information. On April 12, 2022, NARA notified Trump that it intended to provide the 15 boxes to the FBI the following week. Trump said, hold on a minute, requested an extension on the turnover to the FBI so that Trump could determine the existence of any privileged materials. Don't give those boxes yet. We got to go through them and see if there's anything that I don't want going to the FBI. The White House counsel's office, Biden's people, granted the request. Okay, you can wait. Hold on a minute. You're right. On May 10th, then, fast forwarding from April, 1 month later, NARA informed Trump that it would proceed with, quote, providing the FBI access to the records requested as requested by the incumbent president, beginning as early as Thursday, May 12th. Hold the phones! What did this just say? On May 10th, 2022, NARA informed Trump that it would proceed with providing the FBI access to the records in question as requested by the incumbent president. That's Joe Biden. Joe Biden requested the documents go over to the FBI. Beginning as early as Thursday, May 12th. The government's filing states that the FBI did not obtain access to the 15 boxes until approximately May 18th. So this document, this order is referencing prior filings showing that the current president, the incumbent President Biden, made a request for NARA to send the documents over to the FBI. Footnote 2 says NARA is an independent federal agency within the executive branch that is responsible for the preservation and the documentation of those records. We're familiar with that agency. So after that happens on May 11th, then, during a period of ongoing communications between Trump and NARA, and before the DOJ got the boxes, the DOJ obtained a grand jury subpoena for which Trump's counsel accepted service. Okay, DOJ says, we're going to come and get that stuff over there. And they sent the subpoena to Trump's lawyers. They said, we take it. We'll take it. We looked at that subpoena here. The subpoena was directed to the custodian of records for the office of Donald Trump and requested, quote, any and all documents or writings in the custody or control of Donald Trump or the office of Donald Trump bearing classification markings. Trump contacted the DOJ on June 2nd and requested the FBI agents visit his residence the following day to pick up the documents. Wow. Very easygoing, it sounds like. Come on by, pick them up. Upon the FBI's arrival, plaintiff's team handed over the documents and permitted the 3 FBI agents and an accompanying DOJ attorney to visit the storage room where the documents were held. This is the judge summarizing. Okay, the judge has summarized everything from both sides. This is her interpretation of the facts. And she's drawing this out so that we have a record upon which she can base her ruling. Because a lot of people are going to be screaming foul about this. They already are. And she wants to lay the framework for why it's justified. And so she's saying and laying out a timeline here. My goodness, a lot of back and forth. Trump's pretty cooperative. The judge writes, the government contends that after further investigation, quote, the FBI uncovered multiple sources of evidence indicating that the response to the May 11th grand jury subpoena was incomplete. They still had library books there. And that potentially classified documents remained at the plaintiff's residence. Based on this evidence and an affidavit that remains partially under seal, must be somebody in Trump's office or somebody who's filling out an affidavit saying, I saw this or whatever. On August 5th, the government applied to the judge for a search warrant to seize items from Trump's residence, citing different U.S. code. Finding probable cause for each offense, the judge authorized law enforcement to search the plaintiff's office, quote, all storage rooms, all other rooms or areas within the premises that could be used by Trump and his staff, in which boxes or documents could be stored. And we were so critical of that language. Do you see this? This is directly from the warrant. All storage rooms and all other rooms or areas or locations, premises used, available to be used by Trump and his staff in which boxes or documents are stored, which is basically anything. Okay, like any room with a cabinet in it. Okay, is basically a place where documents could be stored. So do you have any room with a cabinet or a closet in it? There you go. That's fair game. Number two, seize the following. Any physical documents with classification markings. So not only the documents, this is the point we made last time, right? They take one box. It's got one classified document in there. They get the whole shebang. They get everything in there. Trump's passports, Melania's underground, whatever. It's all a part of that. Along with any containers, boxes, including any other contents, because the judge was just like, yeah, whatever you want, just take it. If it's, yeah, just take whatever. In which the documents are located. This is directly from the warrant, as well as any other containers or boxes that are collectively stored or found together with the aforementioned documents and containers or boxes. Okay, so if you find a problem in one box, not only do you get that one box, you get the boxes to the left and to the right of it, top, below it. In fact, just get the whole container because it's in the container. Just get the whole room, which is basically what they did. And the point that we made on this is that this is what shows, in my opinion, that they completely staged that photo. If you go through the inventory list that they released last week, we did a whole video on this. They went around to box after box, and I'm 90% sure they just pulled the one classified document out of the boxes, threw them on the ground, and consolidated the bad documents. They went through the M&Ms or the Starburst, and they picked out all the red ones, and they put them together. And they said, look at all these terrible red documents. They're troubling. And they did that intentionally, because if you actually read the inventory, that's not what it looked like when they went and picked them all up. The search warrant says, information, including communications in any form regarding the retrieval and so on, all can be picked up, citing the search warrant. So all of that gets approved. Judge Reinhardt says, whatever you need. It's Trump. Who cares? Yeah, go get it. On August 8th, after the warrant came back, pursuant to the search warrant, the government executed an unannounced search of the plaintiff's residence. Just showed up like he's a mob boss. As reflected in the detailed property inventory that we rammed through last week, that was submitted by the government, the agents seized approximately 11,000 documents and 1,800 other items from the office and the storage room. Seized property is generally categorized on the inventory as 27 boxes containing documents with and without classification markings, along with photographs, documents, and other materials. Now, this is the point that we were making, is that of this 11,000, only a tiny subset of those are classified, confidential, top secret, whatever. And of that subset, even a smaller fraction of those might only be folders, or all of it could be declassified or completely irrelevant to any national security issues because it expired or it's geographically irrelevant. There's all sorts of reasons why. We've got a couple footnotes. The figures come from the government filings, and based on a detailed inventory of the 11,000 documents seized, roughly 100 contain classification markings. Okay, so 100 out of 11,000. Whatever that percentage is, it's low. 100 out of 11,000. And they ran out of here. And the headlines, if you look on Reuters and you look at certain articles, it's all that, right? 11,000 documents Trump had. Wow. Shortly after, only 100 are containing classification markings, okay? And again, we don't even know if they're classified, actually. Shortly after the search of the residence, plaintiff's counsel spoke with the government and requested a following. So Trump says, hey, guys, you guys just searched our property. We need some items here. We want a copy of the affidavit in support of the warrant. Remember, they wouldn't give it over to them. They just gave them a copy of the search warrant and the cover sheet, but not the actual affidavit. But Trump's lawyers also wanted the government's consent to the appointment of a special master. They said, can you just appoint somebody? We think this is a very problematic search and seizure. How about you just appoint a referee, somebody to monitor all this stuff? The government denied those requests. So the government was not willing to appoint a referee in this unprecedented raid of a political opponent in America. They said, nope, we got it covered. We don't need a referee. And they also didn't give him a copy of the affidavit so that they could see it, right? They said, no, this is not how we normally do investigations. So even though this is unprecedented, we're going to follow the precedent. And you don't get any access to this stuff, even though there's 70 plus million people who are going to be very upset about what we just did. So they're not being very open and transparent. Footnote 5. They say the exact date of that conversation is unclear, but all agreed that the conversation took place when the government denied the requests. They say all agreed that the government did deny the request after the search. Trump and his lawyers, they reference August 11th in the motion, 3 days after the search. The government does not offer a different view. Counsel for the government stated that the request for a special master was rejected the morning after the search. Okay, so they're sort of quibbling over times now on when this conversation happened, but it doesn't matter when it happened. They both agree. Denied. No affidavit, no special master. The judge writes, so in the absence of any agreement between the parties, on August 22nd, Trump filed the motion seen here, the motion for judicial oversight. And he wants a couple things. One, he wants a special master to oversee the review of the materials, and specifically wants to identify personal property and privilege. So as they're rummaging through all these boxes, two filters. First, filter out the personal stuff, give that back to Trump. Number two, filter out the privilege stuff, either attorney-client or executive, give that all that also back to Trump. Number two, they also want the enjoinment, meaning the stopping of further review of the seized materials until the special master is appointed. And so that got ordered today, granted. They want a more detailed receipt for the property, which we already looked through some of that. And number four, they want a return of any item seized outside the scope of the search warrant, called in excess. So those four things. Following the receipt of Trump's request, the court ordered Trump to elaborate on the basis for the court's jurisdiction and the type of relief that was sought. Why do you think we should be hearing this complaint here, Trump? Who do you think you are? Why'd you walk into my courtroom and tell me to do something about this? This isn't even I didn't issue the search warrant. Go talk to Reinert or whatever. And so, right, the judge is saying, you show me why you need to be here. Trump did. Plaintiff did so via a supplement to the motion filed on August 26. Consistent with the rule of federal rules of civil procedure, the court issued a preliminary order. Judge says, I'm following the rules. I issued a preliminary order indicating that the court has an intent to appoint a special master. Saying, I'm leaning this way, actually. This is kind of a big deal. Shortly thereafter, the government went, what? Freaked out. They said the government appeared in this action, and they filed a notice of the receipt that same day. Plaintiff Trump executed a service the same day, meaning the government got served with the complaint. The government then filed under seal the notice by the investigative team of the status review, which we reviewed previously, and they attached the detailed property inventory as ordered by the court. Remember, the judge said, I'm going to probably grant special master, but I want two things. I want the update on the investigation. File that, please. And I also want the more detailed property inventory to be released. And this is not the ultra granular detail, but we get a little bit more. Remember, the first inventory list was just like box A31, box A5, box 37. We didn't get any details. The judge said, we're going to open up a little bit more. We're going to zoom in on that map so we can see a little bit more. The investigative team report is now unsealed. It indicates that the team has already reviewed all of the seized materials in furtherance of its investigation. The seized materials are going to continue to be used to further the investigation as it takes further investigative steps, is what they said. They've got to do witness interviews. They're going through grand jury proceedings. They're going to go get, subpoenas and probably an indictment. The judge writes, she says, while acknowledging that the investigators, quote, already examined every seized items other than materials that remain subject to the filter protocol, the government clarifies that, quote, review is not a single investigative step, but it's an ongoing process. Remember this, at the close of the government's motion, they were saying, Judge, look, you kind of asked how far along we are. It's kind of like we're not going to ever be done with this stuff, okay? We're always going to be investigating, always going on and on and on. We're just going to be round and around we go. And so, Judge, we're never ultimately going to be done with any of this stuff. So they're kind of saying that the point of the question is not really relevant because it is something that, hang on, making a quick change. Going on slow mode over here on the YouTube. Okay, so they're saying, it doesn't really matter either way. We'll go back to the motion. The court writes, judge writes, the government also states in its report that were facilitating a classification review, and they filed under seal saying the filter separation team is working hard. This order refers to the content of the rest of the document. So here, after all of that, the judge is giving us a recitation of the facts so that we're all on the same page. We're all up to speed. We finally get some discussion. Now, often in these documents, the way that these are structured is, remember, it's issue, rule, analysis, conclusion. Call it IRAC in law school. And there's different ways to sort of interpret that, but that's the general rule. The judge is now giving us a little bit of the sort of analysis, the application, and actually some of the rules are being laid out here first. And what I want to do is really stick to the analysis, I guess is the better way for me to phrase this. There's going to be a lot of rules, a lot of legalese. I want to kind of fly through that and hit the highlights. But one of the big highlights was jurisdiction. They said originally, Trump, you don't even have any standing to come into a court. Why are you even here in the first place? They said the property's not yours. The property was lawfully seized as a result of a valid warrant, and you've got no claim to this. Therefore, you have no standing. You can't even file the claim. So this is a little bit of sort of legalese, but I do think it's important because they're trying to even deny him the opportunity to be heard. And there's going to be a lot more of that coming up as this lawfare continues. The court tells us jurisdiction. As previewed, Trump initiated this plaintiff with a hybrid motion that seeks independent review. And they say, though this is somewhat convoluted, this filing is procedurally permissible, right? And it actually creates an action in equity, right? It's unusual. A lot of people, a lot of legal people, what the heck is going on here? Because of the way Trump filed it and how all this works. But they said it is procedurally permissible. Rule 41G allows move-ins prior to the return of the indictment to initiate standalone actions in a district where their property was seized. See that? United States versus Wilson. So the prosecutors were saying, you can't even come into this courtroom. The judge is saying, yeah, they can. Like, this is a little weird how this is all working. But yeah, he can do it. There it is. Rule 41G. It allows him to do it. And they go through the rest of these rules, right? Rule 41. They say, in other words, to entertain plaintiff's request, the court first decide whether it can exercise equitable jurisdiction. And then we're going to go through all of that, right? And that's a lot of heavy lifting, legalese stuff. And so we're going to fast forward through most of that. They say, upon full consideration and the exceptional circumstances presented, the court does deem the exercise of this jurisdiction to be warranted. I rely on the number of different factors from a number of different cases. In that case, the following things happen. And basically what the court is talking about here is equitable jurisdiction means, does the court have the ability to mandate somebody does something or stops doing something? When we hear the words enjoin or injunction, we're literally saying that, right? Rather than deciding whether a person is guilty or not guilty, okay? You know, does the court have jurisdiction to decide that? Yeah, the criminal courts do. You know, does a judge in a tort case have the authority to award a monetary fee? Yeah, right, because that's part of the rules. But what about equitable jurisdiction? What happens if we say somebody has a box of documents and they're rummaging through it right now? How do you say, stop rummaging through Melania's clothes? Do you have the power to issue an injunction to enjoin somebody? That's called equitable jurisdiction. And the court says, yeah, look, I've analyzed it. Those factors, although mixed, ultimately counsel in favor of exercising jurisdiction. So I've done my analysis on it, and I think I do have the ability to say, stop rummaging through her brasiers. They go through all the various factors, and you can see, right, the judge is saying they are mixed, agrees with the government in some, agrees with Trump in some of these, and goes through the various reasoning for the equitable jurisdiction, concluding that there are limits on this, but that's outside the scope. For now, the circumstances surrounding the seizure in this case and the need for procedural safeguards are sufficiently compelling to get plaintiff past the courthouse doors, okay? Trump can get in here because of those factors. I at least have jurisdiction, okay? So he can come through my doors because, yes, this is the appropriate court. Now, the next question, standing. Remember, Trump said that I can file a complaint here, and they said, no, those are our records. So you don't even have a basis for coming out here in the first place. Judge says, no, let me ask about standing. He says, judge writes, there is another threshold argument the court must consider. Prosecutors say Trump doesn't have any standing to even be here. They say that Trump lacks standing because the seized property is presidential records over which Trump lacks a possessory interest. Okay, he doesn't have the property in his possession. Regardless of whether it's his or not, it's not physically with him. Therefore, he can't bring an action about something he doesn't control. Judge says the government relies on the definition of, quote, presidential records under the Presidential Records Act. We have a footnote here, footnote 12. It says here, Judge writes, at the hearing, the government argued that the equitable concept of unclean hands bars the plaintiff from moving under the rules. Right? How do you get the benefits of the rules if you're sort of exercising the use of the rules in a way that is against the rules? Your hands are unclean in using the rules. They cite a different case. And judge says, yeah, this is not analogous to the circumstances here. Trump hasn't pled guilty to any crimes. And so the government hasn't explained how plaintiff's hands are unclean with respect to any of this stuff. So, yeah, they're talking about cocaine in that case. And here, Trump hasn't pled guilty. So they're saying, yes, we still have the presumption of innocence in this country. Thanks. But we're not falling into that one. So the judge writes, Trump opposes the government's standing arguments, saying they're premature and they're flawed. In Trump's view, what matters now is his authority to seek the appointment of a special master, not the entitlement to possess the records. Right? We're not talking about the underlying issue. That's still to be litigated. Are these presidential records or are these personal records? Same thing was debated when Judicial Watch tried to go get the records over from NARA in the Bill Clinton case. Clinton said, those aren't presidential records. These are personal records. I can put these in my sock drawer if I want to. And the court said, it's true. How are we supposed to litigate that? Amy Berman said, what do you want me to do, Judicial Watch? Do you want me to go into Clinton's office and get him out of his sock drawer? How can I, as a district level DC Circuit Court judge, do that? It's a non-justiciable thing. The whole thing was rightfully kicked back over, and now it's up for debate again. So they're saying we have to argue over all of that in the future. Trump is saying right now the only thing that we're debating is a special master. That's the only thing that's relevant. Judge says, moreover, Trump adds, even assuming that the court were inclined at this juncture to consider plaintiff's potential claim of unreasonableness, under the Fourth Amendment, settled law permits him as the owner of the premises searched to object to the seizure as unreasonable. Because if you didn't have the ability to file a complaint about a search warrant, then anytime the cops came in and seized anything, you would just have to sit there and twiddle your thumbs, I guess. Judge writes, having considered these crisscrossing arguments, the court concludes that Trump is not barred as a matter of standing from bringing this action and invoking this court's authority to appoint a special master. He's got standing. To have standing, the judge says, to bring a rule, the movement, in this case Trump, must allege a colorable ownership, a possessory or a security interest, and at least a portion of the seized property. And he does. All sorts of claims to, if you want to be technical about it, the passports and other items, those are his, right? And other items, presumably the personal things, clearly he's got some authority over those. He's got a possessory or an ownership interest in that property. Once a possessor of the property that has been seized necessarily suffers an injury that can be redressed, and at least in part by the return of the property. Okay, you took my thing that is harmful to me. If you return the thing to me, that means I pretty much got an interest in that property, doesn't it? Contrary to the government's reading, they find that this exists. They say the government argues here that Trump has no property interest in any of the records seized. That position calls for an ultimate judgment on the merits as to those documents and their designations. Exactly right. It was a ludicrous argument that the government was proffering. And many of you actually out there, I think, said this was kind of insulting, was it not? It's trying to sort of slide one by the judge. The ultimate issue of the case is about the designation and the categorization of these documents. Judge says, prosecutors also concede that the seized property includes personal effects, right there, 520 pages of potentially privileged material, and at least some material that is in fact privileged. So we've got three gigantic overbroad categories. Personal effects were seized from Trump, 520 pages of privileged material, potentially, and some material that, is absolutely, in fact, privileged. Judge says, this is sufficient to satisfy the standing requirement. Okay, you took his property. He's got a strong interest in all of these properties. Don't even debate that any further. Paragraph 3. The judge says, all right, we're now going to talk about the need for further review. Why do we need to appoint a special master? The judge explains, having determined that the exercise of the jurisdiction is appropriate, meaning I can hear this case, and that Trump has standing to bring this case, the court next considers the need for further review. I can hear it. You can come through my door. Trump is the right person to bring it. But why do we need somebody else to oversee all this stuff? Let's look. The judge says, although some of the seized items, articles of clothing, and so on, appear to be readily identifiable as personal property, the parties and their submissions suggest the existence of genuine disputes as to, number one, whether certain seized documents constitute personal or presidential records, and to two, as to whether certain seized personal effects have any evidentiary value, right? They're trying to pull fingerprints off this stuff. Who else was in the room? Did this person fingerprint match this other person who didn't have access to touch the confidential folder or whatever? They say because those disputes are bound up with Trump's requests, the court must receive evidence from the parties accordingly. And so therefore, that step calls for a comprehensive review of the seized property. The judge continues, she says, review is further warranted as previewed for determinations of privilege. The government forcefully objects even with respect to attorney-client privilege, pointing out that the privilege review team has already screened and seized property and is prepared to turn over 520 pages of documents. They're saying, the government is saying, Judge, we don't need somebody to come in and look at any of this stuff. We've already reviewed it and we're ready to turn everything over. Our PRT is amazing. It's privilege review team, Judge. It's PRT. They're the best. And so they're just going to turn this stuff right over to you. And the judge says, okay, I understand that's your intention, but here's my opinion and my order. The judge says, to begin, the government's argument assumes that the privilege review team and that their initial screening for the material was sufficient, yet there is evidence from which to call that premise into question here. Citing some case law. As reflected in your own report from the PRT, the investigative team has already been exposed to potentially privileged materials, meaning the people who shouldn't have seen the privileged materials have already seen it. The investigative review team has already been exposed to documents that should have been filtered out by the privilege review team. So you guys are saying you did a great job, but there's evidence you didn't. Judge says, without delving into the specifics here, the privilege review team's report references at least 2 instances in which members of the investigative team were exposed to materials that were then delivered to the privilege review team and, following another review, designated as potentially privileged materials. Judge says, look, those instances alone, all right, even if entirely inadvertent, like even if you didn't mean to do this, they yield questions about the adequacy of the filter review process. You say that you've got a good job, but, close is not good enough. Should have caught all this stuff. The fact that you've got 2 instances, okay, not just 1, 2, where the investigative team is catching stuff and they go, whoa, that means that the investigative team, okay, the people who are putting on Melania's clothes, they put on on one of her brassieres or something or whatever, a coat jacket, and they're rummaging through the coat jacket. They're like, this looks fabulous on me. And they open up the jacket pocket and he pulls out a piece of paper and he goes, oh, what's this? Probably the nuclear codes in Melania's clothes. And he unfolds it and he goes, and he's on the investigative team. So he unfolds this thing and he says, oh, it's a letter from Evan Corcoran. It says, dear Mr. Trump, you go, oh, Evan Corcoran, that's Trump's lawyer. That's privileged material. And he goes, oh, and his partner says, Special Agent Johnson says, take off that coat jacket. And they run all this back over to the privilege team and they say, we've got this privileged document now, right? And the judge is saying that's a big problem because they read the letter from Evan Corcoran. How can you say that they're separated out when they're clearly not? Paragraph ends with a footnote referencing footnote 13. 13, the judge writes. In explaining these incidents at the hearing, counsel from the privilege review team characterized them as examples of the filter process working. He's like, yeah, see, they pulled it out. They brought it right over to us. The investigators identified it and they brought it over to us. It's working, Judge. It's working. And the judge says, the court is not so sure about that. These instances certainly are demonstrative of integrity on the part of the investigative team members who are returning the potentially privileged materials. Like, yeah, the people who find the bag of money and they bring it over to you and they're like, no, it's all yours. It's all there. I didn't look at it. You're like, wow, that's pretty amazing. But they also indicate that on more than one occasion, the privilege review team's initial screening failed to identify the privileged materials. The government's other explanation that these instances were the result of adopting an over-inclusive view of the material out of an abundance of caution also does not satisfy the court either. Even accepting the government's untested premise, the use of a broad standard for potentially privileged material does not explain how qualifying material ended up in the hands of the investigative team. Perhaps most concerning, the judge says, the filter review team's report does not indicate that any steps were taken after these instances of exposure to wall off the two tainted members of the investigation team. They just said, what'd you see? Oh, did you turn it over to the PRT over there? Yeah. Okay, we'll take off her clothes. Okay, and just go back to it. You're fine. No problem. In sum, the judge writes, without drawing inferences, there is a basis on this record to question how materials passed through the screening process, further underscoring the importance of procedural safeguards and an additional layer of review. They write, for instance, the government's taint team missed a document in a prior case. And so we'll fast forward through that case law. Judge says the government's argument that another round of initial screening is unnecessary also disregards the value added by an outside reviewer in terms of, at minimum, the appearance of fairness. This is the second time the judge has said this, right? The second time she said the appearance of fairness. The first time was all the way at the top of the document. At minimum, the appearance of fairness, which means to me the judge doesn't think this is even remotely looking fair at all, saying that as it stands currently, it's looking entirely one-sided. And if you want even the appearance of fairness, not even actual fairness, right? Just the appearance, you got to at least appoint a special master. Judge says, even if the DOJ filter review team often pass procedural muster, they're not always perceived to be impartial as special masters. Concerns about the perception of fair process are highlighted here, whereas here, the privilege review team and the investigative team, my goodness, contain members from the same section within the same DOJ division. We're going to rewind that one. It's amazing. Concerns about the perception of fair process are heightened where, as here, right here in this case, the privilege review team and the investigation team contain members from the same section within the same DOJ division. So they go bowling together and they go to the bars together and they're probably on the same fantasy football teams, even if separated for direct reporting purposes on this specific matter. They still hang out. They go to the bar. What'd you find over there? What kind of goodies did you get in your trick-or-treat bag? A commitment to the appearance of fairness is critical now more than ever, writes the judge, footnote 14. Government implies, says the judge, that an additional independent review for any privilege issues by a special master is only appropriate where the search of a law firm occurred. Where, whatever the extent of that argument, the judge says, it fails decisively here, right? They're saying you can only appoint a special master like if somebody went and raided my office and we rummaged through all of our stuff and they'd appoint a special master. They're saying, Trump's not a law firm. Judge says, well, okay, I can understand that distinction, but it doesn't matter here. They say special masters do ordinarily arise in the settings of law firms and attorneys' offices here, but the court does not see why these concerns would not apply, at least to a considerable degree, to the office and the home of a former president. Like, why does the location of a lawyer who's got attorney-client privilege, why is that more important than, executive presidency, total executive privilege. It's like if it applies to law firms, it's got to apply to the former president's house, no? Moreover, at least one other court has authorized additional independent review for attorney-client privilege outside of the law firm context in politicized circumstances. Talking about the Project Veritas case, actually. Appointing a special master to conduct a review of material seized from the homes of Project Veritas employees. Wow. Judge says, though the foregoing analysis focus on attorney-client privilege, the court is not convinced that similar concerns about executive privilege should be disregarded. Government says executive privilege has no role to play here because a former head of the executive branch is entirely foreclosed from asserting executive privilege against the current executive branch. And this is that debate, right? Can Biden waive the executive privilege of Trump? And can Trump assert it against an incoming administration? Who's got the authority and how does all this work? The judge says, in the court's estimation, the government's position arguably overstates the law. The court is saying, look, prosecutors, I know you came in here and you said Trump has nothing, he can't do anything, he's a total loser, but I think you're probably overstating your powers here. The judge says, in a case called Nixon back from 1977, a case involving a review of presidential communications by a government archivist, the Supreme Court expressly recognized that, one, former presidents may assert claims of executive privilege. Wow. Former presidents may assert claims of executive privilege. 1977 case. Well, two, the exception of confidentiality of executive communications. The expectation of the confidentiality of executive communications, number two, is subject to erosion over time after an administration leaves office. And number three, the incumbent president, quote, is the best position to assess the present and future needs of the executive branch for the purposes of executive privilege, right? And so part of this is saying that the current president might need something from the prior president. And if the prior president says, I can't give you any of that stuff, then the current president might be able to go say, I need it to do my job, right? If you're working at a job somewhere, you got to leave your files behind if you move on, so somebody else can work them. At least that's how it often works in the law. Here, the Supreme Court did not rule out the possibility of a former president overcoming an incumbent president on executive privilege matters, right? They only set out those three variables, but it doesn't say anywhere in that case that former presidents have no executive privilege. In fact, it says right here, they may assert them. The judge says so. If you interpret this in a light most favorable to Trump, it could be possible that he could overcome an incumbent president on executive privilege. The judge says, look further, just this year, in fact, the Supreme Court noted that, at least in connection with a congressional investigation, quote, the question whether and in what circumstances a former president may obtain a court order preventing disclosure of privileged records from his tenure in office in the face of a determination by the incumbent president to waive the privilege are unprecedented and raise serious and substantial concerns. Judge Kavanaugh wrote that, respecting denial of application for a stay, right? It's bumping up on the door of the Supreme Court. And judges are saying, holy moly, are you serious right now? We're going to battle this out. That's going to be unprecedented and raise serious and substantial concerns. And the Biden administration was just like, yeah, we're just going to go, we're going to run right into that by invading his house. Kavanaugh wrote, a former president must be able to successfully invoke communications privilege that occurred during his presidency. Concluding otherwise would eviscerate executive privilege for presidential communications. Yeah, it says a former president must be able to successfully invoke the privilege that occurred for communications that occurred during his presidency, even if the prior president doesn't support the claim. Otherwise, what is the privilege? Thus, even if the assertion of executive privilege by the plaintiff ultimately fails, meaning if Trump ultimately fails, that possibility, even if likely or unlikely, does not negate his ability to raise the privilege as an additional matter. And additionally, because the privilege review team did not screen for the material potentially subject to executive privilege, further review is required for that additional purpose. So it sounds like, my goodness, they didn't even think about executive privilege. They didn't even attempt to screen for it because they said he doesn't have it. So they made a conclusion on the law when the judge is saying there is no conclusion on that law. 16, footnote, the court recognizes that under the PRA, the U.S. District Court for the District of Columbia shall have jurisdiction for any issues brought under the Presidential Records Act. Saying because the privilege review team did not screen for executive privilege material, we got to have further review. And citing a 1977 Nixon case. So do you see what these people have done? They have made their own determinations on what the law means. They said Trump doesn't have executive privilege. That's not what has been found. The Supreme Court hasn't said that. In fact, according to this judge, the precedent has said the opposite, that there's several different variables that come into play, and there is a possibility in one, however remote possibility it is, there still is a possibility a former president beats an incumbent president on the issues of privilege. Paragraph, appointment of a special master. An independent special master should conduct an initial review that is warranted here. The judge says, Rule 53A of the rules tell us the following, that the court can appoint a special master to address matters pending during pretrial proceedings. Judge says here, as noted, the government's inventory reflects a seizure of approximately 11,000 documents and 1,800 other items from Trump's home. Considering the volume of the seized materials and the party's expressed desire for the swift resolution of this matter, a special master would be better suited than this court to conduct the review. Judge says, I don't have enough time to do this. The appointment of a special master is not uncommon in the context of attorney-client privilege, nor is the appointment of a special master unheard of in the context of potentially executive privileged material. In fact, the government itself recently contemplated and requested the appointment of a special master for review of both attorney-client privilege and executive privilege in another case. Oh, the judge and the judge's clerk doing a little bit of independent research here. They say, oh, look at this case. In the matter of search warrants executed on April 28, 2021. All right, so you can look this up. MCO, JPO 00425 N21. Filing out of the Southern District of New York, May, it says, under exceptional circumstances, the appointment of a special master to review seized materials from an attorney may be appropriate. In other words, the judge is saying, hey, government prosecutors, you filed another thing over there in the Southern District of New York. I mean, we're here in Florida right now. But in New York, you're saying that it may be appropriate to appoint special masters over there. So why isn't it appropriate over here? They say, most importantly, courts recognize that special masters uniquely promote the interest and the appearance of fairness and justice. Special effort must be taken to further those interests here because this is a massive case. And so finally, the judge says, as a final matter, the court determines that a temporary injunction on the use of the seized materials is appropriate and equitable to uphold the value of the special master review. Footnote 17. Meaning you cannot use that material anymore until it is approved by the special master. Otherwise, the special master doesn't have any teeth to it. Footnote 17 says, although the motion asks the court to enjoin the government's review of the materials pending the appointment, it is clear that this request is meant to cover the government's temporary use of the materials as appropriate. And they presented that during the hearing, so this is just a clarifying mark. It is not entirely clear whether courts must perform additional analysis under the rules, but many courts have explicitly issued injunctions relating to the special master review, have done so without discussing those rules. And therefore, the judge says, the court is satisfied that plaintiff has a likelihood of a success on the merits in challenging the privilege review team and their protocol. They say even without a temporary injunction, the court would exercise its discretion to appoint a special master regardless. And we're saving repetition, the judge says, minimizing some repetition, but you get what I'm doing, says, for the same reasons, the risk that the government's filter review team will not adequately protect Trump's privilege and personal materials, that has been sufficiently established Trump has established that he might suffer irreparable injury. And with regard to that factor, the judge does a little bit more analysis. You see some serious case law here, 2021 cases, going through the different factors for the injunction. For the reasons set forth above, the court determines that a temporary injunction on the government's use of the seized materials, meaning the stopping of the using of them for criminal purposes, is in fact warranted. The court is mindful that restraints on criminal prosecutions are disfavored, footnote 21, citing another case, but finds that the unprecedented circumstances here call for a brief pause to allow for a neutral third-party review to ensure a just process with adequate safeguards. Makes total sense. If you wanted fairness, if you wanted a referee, if you were the DOJ and you were doing something entirely unprecedented, wouldn't you want somebody appointed to review this so that you could default back and say, he says even it's appropriate? But they have done the opposite. Conclusion, the judge writes, accordingly, it is hereby ordered and adjudged as follows. 1. A special master shall be appointed to review the seized property, manage the assertions of privilege and make recommendations thereon, and evaluate claims for the return of property. The exact details and the mechanics of this review process will be decided expeditiously following the receipt of the parties' proposals as described below. Special master is coming on board. The government is, number 2, temporarily enjoined from further review and use of any material seized from the plaintiff's residence on August 8th for criminal investigative purposes pending the resolution of the review process done by the special master. The government may continue to review and use the materials that were seized for the purposes of intelligence. We get a deadline, September 9th. The parties shall meaningfully confer and submit a joint filing that gives us a list of proposed special master candidates, which will be a lot of fun to go through. B, a detailed proposed order of appointment in accordance with the special master's duties and limitations, any points of disagreement that you guys have here, and the court is noting in 5 that the court reserves ruling on the plaintiff's request for a return of property pending further review. Trump says, I want stuff back. The judge says, hang on a minute, let's get the special master cited on here, and if this person, him or her or they, decides that they want to turn this stuff back over to you, I'll review it at that time. Judge Cannon says this order is subject to modification as I deem appropriate. Done and ordered this 5th day of September, 2022. Signed, Judge Aileen M. Cannon, United States District Judge out of Florida. And a big day for Donald Trump and his defense lawyers, celebrating the appointment of a special master and a big victory for the defense. Meanwhile, we've got other reaction. And of course, Donald Trump was out over the weekend and he was giving a rally conversation where this is his first speech out. I think this is his first appearance. Donald Trump making his first appearance after the raid at Mar-a-Lago at a rally. And he's talking about the experience. He says that, well, they weren't there, but they were able to see and look at the footage that came from the surveillance cameras, and they could see the FBI agents rummaging around through Melania's clothes. But we learn it may not have just been her closet that they went through. In fact, Trump tells us a lot more details about that raid on his house.
On a phony pretext, getting permission from a highly political magistrate who they handpicked late in the evening, just days before the break-in, and trampled upon my rights and civil liberties as if our country that we love so much were a third world nation. We're like a third world nation. They rifled through the First Lady's closet, drawers, and everything else. And even did a deep and ugly search of the room of my 16-year-old
son. And I don't know what happened with that audio. Let's start that again because it's sort of out of sync. 16-year-old son Barron Trump.
Drawers and everything else. And even did a deep and ugly search of the room of my 16-year-old son.
Wow. Nuclear code's probably in there from the FBI
leaving
agents.
everything they touched in far different condition than it was when they started. Can you believe it? The FBI and the Justice Department have become vicious monsters, controlled by radical left scoundrels, lawyers, and the media who tell them what to do, you people right there, and when to do it.
Media totally in control, moving Joe Biden room to room. Meanwhile, they're out there in Barron's bedroom. And, the FBI agents, we do know that, they like certain toys out there. We have covered this one for some time. They got that FBI set. I'm sorry, the Capitol Hill set that was apparently seized by insurrectionists who wanted to destroy America. So maybe that's what they were in Barron's room for. He's a young guy, probably not playing with a lot of Legos anymore, but maybe they were playing with Legos in there. Maybe they wanted to see if Barron had the Capitol building Lego set and he was a part of Trump's entourage to seize power.
They're trying to silence me, and more importantly,
they are trying to silence you. They are trying to silence you.
I don't know what is going on with my audio on this clip. All right, so you get the gist of it. That's Donald Trump, and he was communicating what happened in Mar-a-Lago. FBI agents not only going through Melania's closet, but also rummaging around through Barron's, I guess, toys or something. Horrendous to think about those FBI agents. All right, and so we also have Donald Trump, who is communicating some of his feelings over on Truth Social. Let's see what he has for us here. Trump says, he posted this on September 4th. He says, so much talk back and forth, including from many patriotic, quote, defenders and supporters about our federal government working every seldom or never used rule and regulation in order to get and destroy at any cost President Donald Trump. Same concepts, anger, and radical left maniacs and rhinos who have been working the system of hoaxes and scams ever since I came down the golden escalator in Trump Tower 7 years ago. They also have the same problem, however. I did nothing wrong. Triple exclamation points. Trump posted September 5th. So they rifled through the living quarters of my 16-year-old son, Barron, and the loved and respected former First Lady of the United States, Melania. But despite proven high crimes and treason and just plain common theft, all pointed out in the laptop from hell and elsewhere, they never raided or broke into the house of Hunter Biden, or perhaps even more importantly, the house of Joe Biden, a treasure trove. This is a country that's unfair and broken. We are truly a nation in decline. Trump also said, the USA is rapidly becoming a third world nation. Crooked elections, no borders, a weaponized Justice Department and FBI. Record-setting inflation, highest ever energy prices, and everything else. And all, including our military, is woke, woke, woke. Most dangerous time in the history of our country. Lastly, Trump said, remember, it takes courage and guts to fight a totally corrupt Department of Justice and the FBI. They are being pushed to do wrong things by many sinister and evil outside sources. Until impartiality, wisdom, fairness, and courage are shown by them, our country can never come back or recover. It will be reduced to being a third world nation. That's Trump on Truth Social, responding to the appointment of a special master and communicating his feelings and new details on the FBI raid of his residence, learning today that they went through even Barron's room to get whatever the FBI wanted. We'll have to continue to cover that, of course, and I hope you join us. Thank you for subscribing and following us and becoming a member over at watchingthewatchers.locals.com.